Most people think the government can't take their house. They think, I worked my whole life, I paid my taxes, this home is mine, and whatever happens, it will go to my kids. And then one medical event happens, one fall, one stroke, one diagnosis that turns into rehab that turns into long-term care, and suddenly the house is no longer safe. Not because someone broke in, not because you did something illegal, but because of a rule most families don't even hear about until the paperwork is already moving. It's called the Medicaid 5-year look-back. And if you're 65 or older, if you own a home, if you've ever helped your children financially, if you've ever written checks to grandkids, if you've ever transferred a car, if you've ever gifted money the way families have always done, then you need to understand what this rule actually does. Because the look-back isn't just a review, it's a punishment system. And the punishment hits at the exact moment you're least able to absorb it. Here's the basic trap. Long-term nursing home care in the U.S. is not cheap. Depending on your state and the level of care, it can easily run $8,000 to $15,000 plus dollars per month, often well over $100,000 per year. Assisted living can be less, but memory care and skilled nursing are in another league. Most people cannot privately pay those numbers for long. Even people who saved responsibly get drained. So eventually, many seniors apply for Medicaid to cover long-term care. But Medicaid is not just health insurance. It's a needs-based program with strict financial rules. And before Medicaid agrees to pay, the state reviews what you did with your assets. Not for the last year, not for the last 2 years, for the last 60 months, 5 full years. A caseworker can ask for bank statements, checks, deposit records, property transfers, deeds, vehicle titles, and proof behind transactions. They're looking for transfers that look like you tried to reduce your assets to qualify, whether you meant to or not. And here's the part that shocks families. Medicaid doesn't care if you were just being a generous parent or grandparent. It doesn't care if you didn't know the rule existed. The system is not built around your intentions. It's built around compliance. So what happens if they find transfers? They don't fine you. They do something worse. They calculate a penalty period. The state totals the value of certain gifts, transfers you made during the 60-month window, then divides that number by what's often called a penalty divisor, sometimes based on average regional nursing home costs. In many states, that divisor roughly falls somewhere around $10,000, $12,000 per month. It varies a lot by state and changes over time. The result is how many months you're disqualified from Medicaid coverage. And that's the brutal part. You apply because you can't afford care anymore, and the state responds by saying, because of what you gave away, you're not eligible for months. So who pays during those months? You do. And if you don't have the money, the nursing home still expects to be paid. Facilities don't run on sympathy. They bill, they collect, they send to legal, and when the bill isn't paid, they look for assets. That's where the house enters the story. Now, a lot of people assume this only happens if you gave away huge amounts, like signing over a house or transferring $200,000 to a child. That's not the only way people get caught. The look-back can capture normal family behavior too, including things like regular checks to a child or grandchild, paying someone else's bills, helping with tuition, selling a car for $1 or far below fair value, forgiving a loan that was never repaid, transferring cash without clear documentation of what it was for. Certain charitable gifts, state rules differ. And there's a very common misunderstanding that traps seniors. People think the IRS gift rules protect them. They don't. The federal gift tax exclusion, the annual number people quote, like you can gift up to X, is an IRS tax concept. Medicaid is a separate system with different definitions and penalties. A transfer that is perfectly legal and non-taxable under federal tax rules can still trigger a Medicaid penalty. 2 different rule books, 2 different consequences. Now let's talk about married couples because this is where the story gets even more painful. If one spouse needs nursing home care and the other spouse is still living at home, the law does provide some protection for the community spouse, the spouse living at home. There is a concept often called the Community Spouse Resource Allowance, CSRA, that lets the at-home spouse keep a limited amount of countable assets. In 2026, the CSRA maximum is in the neighborhood of $150,000 plus. Exact amounts are updated periodically and vary by context. But here's what people miss. That number can sound comforting until you translate it into real life. That at-home spouse still has to pay property taxes, home insurance, repairs and emergencies, food, utilities, gas, Medicare costs and prescriptions, everything life requires, and they may have to do that for 10, 15, even 20 years. Meanwhile, the spouse in care may be generating bills in the range of $9,000 to $15,000 per month. So even though there's protection, the system still forces many couples into a financial squeeze that doesn't feel like protection in the real world. Now here's the sentence almost every senior says at this point. Okay, but the house is exempt. They can't take the house. That statement is half true in a way that gets families destroyed. In many states, the home is treated as an exempt asset for eligibility purposes while certain people are still living in it, like the applicant's spouse. Medicaid typically won't force an immediate sale just to qualify. But the story does not end there, because after the Medicaid recipient dies, another system activates, one families almost never see coming until the letter arrives. It's called the Medicaid Estate Recovery Program, MERP. Federal law generally requires states to attempt recovery from the estates of many Medicaid beneficiaries who received long-term care benefits after a certain age, commonly 55 plus, although the exact scope and process vary by state. The state files a claim against the estate to recover what it paid for care. And what is the most common major asset left in an estate? The house. So the home you thought was protected during life can become the recovery target after death. Your heirs may be told, pay the claim or sell the property and satisfy the debt from the proceeds. Average estate recovery amounts vary widely. Some are tens of thousands, some exceed $100,000, and in high-cost care situations, they can be much higher. And no, families don't always have a clean negotiation option. Some states have hardship waivers, some have exemptions, and there are situations where recovery is delayed or prevented. For example, if a spouse is still living, or in certain cases involving disabled children. But most families don't know these rules, don't request the right relief, and don't plan in time. So the emotional reality is this. Many people spend their entire lives believing their home is their legacy, and then it gets converted into a reimbursement source. Now let's add the part that almost nobody wants to talk about. In some states, adult children can also be exposed in certain circumstances. There are filial responsibility laws on the books in a number of states. Enforcement is inconsistent, and it depends on facts, location, and who is suing. Sometimes it's the facility rather than the state. But cases have occurred where nursing homes pursued adult children for unpaid balances. Even if this doesn't happen to most families, the fact that it can happen in some places is enough to make planning worth taking seriously. Here's a real lifestyle scenario that shows how fast this can unravel. A widow helps her daughter over a few years. Birthday checks, holiday money, a car repair, just a little help, nothing outrageous. She doesn't track it. She doesn't think it matters. She's not trying to hide assets. She's just being a mother. Then she needs skilled nursing care unexpectedly. During the Medicaid application, those transfers get counted, a penalty period is calculated, Medicaid refuses to pay for months, the nursing home bills continue, the widow doesn't have the money, the facility looks at the remaining asset, the house, then after death, estate recovery enters. And the daughter, who thought she was receiving love and help, realizes those small gifts help trigger a chain that ends with the home being sold. This is why the Medicaid lookback is so feared. It punishes normal behavior if it happened inside the wrong timeline. Now, to be fair, there are planning strategies and there are legal exceptions. Some transfers are not penalized in many states, like certain transfers to a spouse or to a disabled child or in specific caretaker situations. But those rules are technical, state-specific, and easy to do incorrectly without the right professional guidance. There's also a last-minute strategy some elder law attorneys use when someone is already close to needing care, often called a half-a-loaf strategy. Wording varies. It's basically an attempt to preserve part of the estate by timing transfers and spend down carefully to survive the penalty period. But it's not a do-it-yourself thing. It's math, timing, state rules, and paperwork. And it often has to be done before an application is filed, not after. Once the wrong forms are submitted, your options can shrink quickly. And that leads to the most important point. The people who lose everything are rarely the people who did something wrong. They're the people who weren't told planning existed. They show up after the crisis: hospital bed, rehab discharge, sudden need for long-term placement, and start writing checks with no idea there were ways to protect the home years earlier. Now, I told you there's a document that can stop a lot of this if it's done early enough. One of the biggest tools is often called a Medicaid Asset Protection Trust, commonly abbreviated MAPT. In plain terms, it's typically an irrevocable trust designed so that certain assets are no longer treated as yours for Medicaid purposes after the look-back period has passed, while still allowing you to retain certain benefits, like living in your home. The exact design depends on state law and your situation, but the general concept is you transfer certain assets, often the home and sometimes other assets, into the trust. The trust becomes the owner. You may still be allowed to live in the home. After the trust is properly set up and funded and enough time passes, the famous 5 years, those assets may be outside the reach of the look-back and/or estate recovery in many situations. This is not a hack, it's legal planning, but it has strict rules and must be done correctly. Some states also use tools like an enhanced life estate deed, often nicknamed a ladybird deed, to help with the home in certain circumstances. Again, highly state-specific and not a substitute for full planning in every case. Now, why don't more people hear about these tools? Because many people walk into a lawyer's office and ask for a will. And a will does not protect your assets from Medicaid spend down and estate recovery the way people assume. A will often just directs where assets go after death, and Medicaid recovery can still claim against the estate depending on state rules and how assets are titled. Planning for long-term care is a different conversation than basic estate planning, and unless you ask the right questions or speak with a professional who focuses specifically on elder law and Medicaid planning, you may never get that conversation. So here's what to do, practically, if this concerns you. First, understand that Medicaid rules are state-run. The details vary. Don't assume what's true in one state is true in another. Second, make a list of any large transfers you've made in the last 5 years. Don't guess, document. If you've been giving family money regularly, it matters to know what the paper trail looks like. Third, if you're serious about protecting your home and independence, speak with an elder law attorney who actually does Medicaid planning, not just a general practice attorney who drafts wills. Ask directly about Medicaid planning options in your state. Ask about an irrevocable trust designed for Medicaid planning, often called a MAPT. Ask about deeds and how your home is titled. Ask how estate recovery works where you live. Fourth, if you do planning, remember this. The 5-year clock typically starts when transfers are completed and properly documented, not when you decide and not when you make an appointment. Waiting is expensive. And finally, tell your adult children the truth. This isn't just a senior issue. It impacts the entire family's future, because if planning isn't done, the house they think they'll inherit may be used to pay back care costs. Quick caution, this is educational information, not legal advice. Medicaid planning is highly state-specific and mistakes can be costly, so you want the right professional for your situation.